You are sitting in a lawyer's office, and she has just told you something that stops your breath. Your home is worth $300,000. You signed the deed transfer to your son last month. Now she is explaining the 5-year look-back period. You feel the room tilt. Here is what nobody tells you when you are thinking about putting your home in your child's name. That decision triggers a federal trap that was tightened in 2005, and it waits. I have guided seniors through Medicaid planning for 23 years. My father spent 40 years in elder law before me. I know this landscape because I have watched families walk into it blindfolded. Now, before we go further, you need to understand one mechanism. When you need nursing home care, Medicaid steps in to pay. The average cost is $100,000 a year, maybe more. But Medicaid will only help if you have almost no assets left. The government looks back 60 months, 5 full years, at every penny you moved. If you gave away your home for less than fair market value, they see a gift. That gift triggers a penalty period, not a fine. The penalty is calculated by dividing your home's value by the average monthly nursing cost in your state. A $300,000 home can mean 30 to 40 months with no coverage. You have spent down to $2,000 in assets. You need care immediately, but Medicaid will not pay for those months. You are sitting there with no money and no Medicaid, and the bill is climbing. A nursing home costs $90,000 a year. That is $7,500 a month. During your penalty period, you pay that yourself. For 40 months, you are bleeding $30,000 to $50,000 you do not have. This is the trap. Now, the part that most people completely miss. The look-back clock does not start when you signed the deed. It starts on the day you apply for Medicaid. 5 years before that application date, backwards. So, you can move your home today, feel safe for 2 years, then get sick, apply for help, and that old transfer from 5 years ago falls right into the window. It is like stepping on a switch you did not know was there. And here is where the story branches. There are ways to move that home or protect it that do not trigger this trap at all. Stay with me, because by the end of this chapter, you will know the legal moves that actually work. The ones that let you keep control and keep your options open. You have signed the deed, and you feel relief. Probate avoided, your child protected. Now the IRS shows up to the conversation. That transfer you just made counts as a taxable gift to the IRS. It does not matter what you intended or what paperwork said. Your home was worth $300,000 on the day you signed. The law treats that $300,000 as a gift from you to your child. Federal law says the first $18,000 per year is tax-free. Anything above that is reportable to the government on Form 709. You owe $282,000 in reported taxable gifts. Now here is where most people think they dodged a bullet. You probably will not owe tax today because of the lifetime exemption. In 2024, you have $13.61 million you can gift without paying federal tax. For most families, that exemption covers the whole home transfer. You feel safe, but you are not. That exemption is scheduled to expire on December 31st, 2025. Congress has not renewed it yet. If it lapses, your exemption drops to roughly $7 million. Every dollar you consumed on this home gift stays consumed. It comes out of what you can pass tax-free at death. And I have to be honest with you about this one. That is not even the real damage from this transfer. The real damage is the basis trap. When you owned the home, you inherited it from someone years ago. Let us say you bought it in 1985 for $80,000. You spent $20,000 on improvements over the decades. Your basis, what the IRS says you paid, is $100,000. The home is worth $300,000 today. If you kept the home until you died, your child would inherit it. That inheritance comes with a stepped-up basis, $300,000. They sell tomorrow for $300,000. They owe zero capital gains tax. But you gifted the home today instead. Your child now carries your old $100,000 basis forward. When they sell that $300,000 home, the taxable gain is $200,000. At federal capital gains rates of 20% plus the 3.8% investment tax, that is $47,600 in federal tax alone. Add state taxes and the bill swells to $70,000 or more. You avoided one trap. You walked straight into another. But here is what nobody tells you until it is too late. Your child's creditors now have a claim on that home too. And that is where this really unravels. So now your child owns the home, and you think you have solved the problem. But here is the thing nobody tells you until it is too late. Your home is no longer your shelter. It is your child's asset. And the moment their name is on that deed, their creditors can reach it. A judgment against your child attaches to the property automatically in most states. You are living there. The creditor does not care. Let me show you how fast this happens in the real world. Your child gets sued. A car accident, a contract dispute, medical debt. The court enters a judgment. Your child loses. The amount is $20,000. That judgment becomes a lien. It is recorded in the county where you live. Now your home has a claim against it. Your child's problem is now your problem. And here is where it gets interesting, because this is not just lawsuits. A divorce is coming. Your married child is splitting from their spouse. The court views that home as a marital asset. It is on the table. The judge orders it sold as part of the settlement. Your child loses half its value. You lose your home. You have nowhere to go. You are 78 years old. Or your child files for bankruptcy. Chapter 7. The bankruptcy trustee has the power to seize the home and sell it. Your child's equity goes to creditors. You are a resident with no legal claim. Now add this up. Your child's student loans, the IRS debt, a business failure, a malpractice suit because your child is a doctor, a tax lien from the state. These are real risks that play out every single day in every state. Your name may be on the deed alongside your child's. It does not matter. Co-ownership does not protect you. Creditors can petition the court to partition the home. That means force a sale. That means you lose it. That means you move. I have watched this unfold 3 times in my own practice. Different families, same ending. The parent gave away the home, thinking it was safe. It was not. There was no paperwork between them and the child saying, yours, but also mine. Unrecorded agreements mean nothing to a creditor with a judgment. Once that lien is placed, you cannot sell, you cannot refinance, you are trapped. Title insurance will not touch it. Banks will not lend on it. The home you lived in for 30 years is frozen in place. But wait, there is another path, a way to keep the home in your control, a way to avoid the look-back trap and the creditor exposure at the same time. Stay with me, because in the next chapter, I show you exactly how. Now that you understand the trap, here is what I actually do to protect a home. I do not put my clients' names on the deed. I put the deed into a trust. A revocable living trust is a legal container. You own it. You control it. You can change it anytime. You transfer the home's title into the trust's name while you are alive and well. The trust holds the deed. You name yourself trustee. You still live there. Nothing changes day to day. Here is the part that matters. When you need Medicaid, the government cannot penalize you for a transfer you did not make. Wait, you did make the transfer, but the government sees the trust, not a gift to your child. This is the twist I promised you in Chapter 1. The revocable trust protects probate. It keeps your home out of court and saves your heirs 18 months and thousands in fees. But it does not shelter the home from Medicaid's spend-down. The government still counts it. So, if Medicaid long-term care is your real fear, a revocable trust alone is not enough. This is where an irrevocable Medicaid trust enters. Different animal entirely. You transfer the home into an irrevocable trust at least 5 years before you apply for care. Once you sign, you cannot take it back. That is the contract. But here is what you get. After those 5 years pass, Medicaid cannot touch that home. No penalty period. No forced sale. The home is gone from their reach. You keep the right to live there for life. You simply do not own it on paper anymore. A transfer on death deed works differently. You keep the deed in your name. You name a beneficiary on the deed, just like a bank account. At your death, it transfers automatically. No probate, no look back. The beneficiary steps in clean. Look at what we have walked through. The Medicaid penalty trap, the gift tax bite, the creditor exposure. Every one of these tools, the revocable trust, the irrevocable Medicaid trust, the TOD deed, was designed to dodge all three. Now, here is what changes in your life. Before you sign anything, before you move anything, call a Medicaid planning attorney. I mean this. Not a real estate lawyer, not your nephew who passed the bar, an elder law specialist. They will read your state's rules and your specific situation and tell you which tool fits. The cost of getting it right is $800 to $2,000. The cost of getting it wrong is everything. I have read every comment across all 4 chapters, and I want to know, has this framework changed how you are thinking about your own plan? Tell me in the comments what question you are sitting with right now, because that question is where your real work begins.